In Gable Insurance AG versus Dewsall and others, the court determined reserved costs following interim applications and a trial where the claimants succeeded against some defendants but failed against another. Applying Dos Santos versus Unitel, the court held that the decision does not create a rule that successful applicants automatically recover costs of interim applications. Where costs are reserved, the trial outcome remains relevant. The successful defendant, Mrs. Dewsall, was awarded her costs of the main claim on the standard basis. For the search order, no order as to costs was made between the claimant and Mrs. Dewsall. The application primarily targeted her husband, and she succeeded at trial, but her inadequate disclosure contributed to the need for the order. For the second freezing order, a cross order was made. Mrs. Dewsall paid 50% of the claimant's costs on the standard basis, while the claimant paid 50% of her costs on the indemnity basis for unreasonably relying on a discredited investigative report. Mutual costs orders were set off. Quote, "The search order was obtained on a without notice basis. By the time of the hearing on the return date, a consent order had been agreed which dealt with the steps to be taken in relation to the analysis of the materials. There was therefore no hearing of a contested application. The Court of Appeal in Dos Santos did not suggest that, in such circumstances, it would generally follow that an award of costs would be made rather than costs being reserved. The purpose of reserving costs is so that the trial judge can take an overall view of the justice of the case, taking into account the result of the trial. Given that I do not consider the principles set out in Dos Santos to be engaged, it seems to me that the fact that Mrs. Dewsall was the successful party is a relevant matter which I need to take into account.
For a detailed summary of this decision, visit tmclegal.co.uk.